to unmute, go ahead and do that, but otherwise keep yourself muted. It helps cut down background noise for the rest of us when we're talking. So if you can keep yourself muted, that'd be great. If you have questions, pop them into the chat also, that we will be monitoring that as we go along. A reminder that today's conversation is just general information. It is not intended to be legal advice. It is not intended to tell your community or you what the correct legal answer to any burning questions you might have is. If you have specific legal questions about yourself and your community, please feel free to reach out to your legal counsel for that, and don't rely on the stuff we talk about here today. We'll try to keep reminding you of that when a specific question comes up that sounds really legal, but just general notice to everyone that we're just having a conversation about what's going on in community association law and not providing specific legal advice to you. And again, so the same thing goes for that chat. Anything you put in there is just please have it be requests for clarification or questions about something you heard. Please don't do legal commentary in there because we aren't providing legal advice here. We have a fairly short list today of questions. So if you have something that is that you have on the mind, feel free to put it into the chat because we may have time to get to it at the end of today's conversation. And then just one quick reminder is the WSCAI is having their annual conference this year. If you have questions about that, you can go to wscai.org, I believe. And the conference is April 9th through 11th. It's 3 days, I think Thursday through Saturday. Might be Friday through Sunday, I apologize. And Jennifer of our office will be presenting on a few panels, so please feel free to look for that. And I think with all that being said, we will get started with our first questions. Anything else to add, Ken, before I do that?
Nope, I'm good.
Okay. The first question is, we are a pre-Wakaiowa HOA. Our CC&Rs state that changes to the CC&Rs only require a majority vote of the entire membership. However, we heard that state law sometimes requires a 100% yes vote. Is that true? And on what occasions would require a larger than 50% vote? And then the second question is, can a board decide on its own to make all membership votes secret and adopt the provisions of 6490 455-9 for all votes and not just those to elect and remove board members and amend the governing documents? And I have to confess, I didn't notice the question about the secret ballots, but I'll answer the first part about the percentages. So just a kind of a reminder to everyone, if you have or are going to be adopting Wakaiowa, the higher of 67% or what is in the declaration or CC&Rs will apply. So, and for everyone starting in 2028. So that's just kind of a general reminder to everyone here. I wasn't clear when you said HOA what you actually meant, so I'm going to kind of go through all of the statutes and the percentages. So if we're talking about a 6434 community, which we sometimes refer to as the new act condominium, that section, which is 6434-264, says that the declaration can be amended provided that a smaller percentage only if all of the units are restricted exclusively to non-residential use. Otherwise, it is 67% of the votes. Let me read that again. The declaration, including the survey maps and plans, may be amended only by vote or agreement of unit owners to which at least 67% of the votes in the association are allocated, or if the declaration provides for a larger percentage. So if your declaration is silent, it would be 67%. If it has something that is a larger percentage than 67, then that would govern for now. Again, if it might be a smaller percentage, only if all the units are not residential, which is not typically what we're talking about here. 6490-285 says the declaration may be amended. That's Wakaiowa community. Says the declaration may be amended only by voter agreement of unit owners to which at least 67% of the votes in the association are allocated, unless the declaration says a different percentage, not to exceed 90% for all amendments or for specific subjects of amendment. So if you're a Wakaiowa community, that would be your percentage. 6438, which is the homeowners association statute, doesn't have specific restrictions in that statutes. So the amount that is in your governing documents would control. So if your CC&Rs say a majority of votes is required to pass an amendment, that's enough. So if the person who's asking the question, if you're a 6438 community and your documents say a majority, then that would be sufficient to pass an amendment. If you're an old act condominium, which is 6432, the method by which the declaration may be amended says that not less than 60% of the apartment owners shall consent to any amendment, except if you're altering property value. And then the percentage shall require unanimous consent of the owners. So we've talked about this before in things like rental restrictions. If you're restricting use of the units comprised in that condominium complex, you may be required to do 100% of the unit owners voting in favor of an amendment. If you have questions about your specific community, because this is a lot of stuff and a lot of lists, and you're going to want to talk to your association counsel about your specific requirements when you're amending your own documents. And I think that's it. Ken, anything you want to add to that?
Well, yeah, I'll add. So one thing which people will sometimes think is a requirement of the statute is related to the case of Wilkinson v. Chihuahua, which was the case where the state Supreme Court ruled that an amendment to restrict the rental of homes was invalid, even though it was approved by a majority of the owners. And that was because the court ruled that the association could not impose a completely new restriction on the property owners. And it's unclear how that case would have been determined if it had been under Ukiah. The case was very specific to the facts of that case. And there's usually an analysis which goes to trying to decide whether or not there is an existing restriction in the covenants which is being tweaked or amended, which is allowed with the amendment percentages, or if it is a brand new covenant or restriction which a property owner could not have predicted would be imposed upon them by the existing documents. And it becomes a very complex analysis, but it's not fair to say there's a general rule that you can't adopt a rental restriction unless you have 100%, because that's not how the courts ruled. But it is something where some people, when they start talking in shorthand, they start thinking you need 100% for an amendment. It would be only true if it's specific to an amendment not contained in any way in your existing documents. And then all the condo statutes and Ukiah do require 100% to change the percentage of ownership interest. So you can't start reallocating the ownership and assessments that are allocated based on ownership without the consent of all owners.
And Ken, what about this question about could the board decide to make all membership votes secret?
So I think the answer is yes, the board could decide to make all membership votes secret.
Mhm.
Ukiah, effective in 2028, will make some very specific votes, those related to board membership and related to amendments, secret. But I can't think of a good reason not to make all of them secret. You still have to be able to provide some means by which the votes could be audited, but I think you could redact out how individuals have voted.
Mhm.
And that's in part because even before the statute required secret ballots, there is case law across the country that the principle of secret ballots for elections is so entrenched in our government that you can keep secret ballots for a homeowner association votes. Anything else you want to add, Lisa?
No, I think that's it.
All right, so the next question is, for a new act condo, is there any requirement to offer owners payment plans for special assessments? So we're going to broaden this to really all types of associations. And the answer is that there is no requirement to offer any kind of payment plan for a special assessment under any of the statutes. If your association needs a lump sum payment to fund an expense, then the board adopts a lump sum payment. And if it is ratified by the membership, then it's a lump sum payment. So payment plans might be offered in two different ways. One is that you might be looking at a large repair project, and the association wants to make payment plans available through a loan which is acquired by the association. And then there are payment plans which might be offered on a case-by-case basis to individuals who approach the board and say, well, I can't pay this in a lump sum. Can I, agree to pay it over 12 months in monthly payments or some other payment plan? And the board always has the discretion to look at, consider, and perhaps adopt a payment plan which has been proposed by an individual. And I think we'll talk about that issues a little bit later. But the answer is the board is trying to find a way to finance some expense. And if they need a special assessment to do it, then they're trying to find a way to do that that is, I'll say, the least oppressive on their ownership, but has the cash flow to allow the association to make the expenditures it needs to. But there is no legal obligation to offer a payment plan of any kind under any circumstances. Anything you want to add, Lisa?
No, I think we just talked a little bit about, there's something to being neighborly. So if the association can't afford to prolong the repayment of that, it doesn't affect the monthly operating budgets. There's not likely to be a reason to reject a payment plan by an owner, and, treat them accordingly, treat them nicely. Okay, next question. If voting for amending, just right, let me see if I can read. If voting for an amendment of a document expired, can the board extend the time period with proper notice and ballots of their own accord? So I think the question is, if you're voting on something and you didn't get enough votes from the membership, can the board extend the time period from which to vote to try and get more folks to weigh in? And the answer to this is yes, the board can extend for a period not to exceed 11 months for the initial deadline, as long as they provide notice to all of the owners that they're doing so. It'd be reasonable to send the notice to all the owners, send it by email, send it by regular mail, but you have to acknowledge that, you have to understand that if an owner decides during that period to change a vote that they've already cast, you need to allow them to do so during that extended time period. Similarly, if someone moves and they have cast of a ballot prior to the move date, you'll need to have a new vote probably for that new unit, is our belief in that. And also, once the new 11-month extension period passes, you will need to get all new votes on the topic if you're hoping to push forward this plan. The statutes are fairly specific about what the notice must state. For example, 6434 sub 6 says the notice must state the time and date by which a ballot must be delivered to the association to be counted, which may not be fewer than 14 days after the date of the notice, and where a deadline may be extended in accordance with G of this section, which G says, if the association does not receive a sufficient number of votes to constitute a quorum or to approve the proposal by the date and time established, the board of directors may extend the deadline for a reasonable time period not to exceed 11 months upon further notice. So just make sure that your notice is very clear and that your period is no longer than the 11 months allowed, and that you need to allow owners the opportunity to change their vote if they choose to do so during that time period. Anything you want to add to that, Ken?
Yeah, I would say that it is really common for boards to need to extend deadlines and pester owners to vote for anything like a declaration amendment, because they need to get such a high level of participation, and apathy among the owners is such a recurring problem. And then the other comment I'd make is that just because you can extend the deadline doesn't mean you're required to. So you could just let a matter die if it doesn't get enough votes. And also, you can't extend it because you don't like the results if you did get enough votes to constitute a quorum. So if you're doing an election and you've got a quorum of votes, you have to accept the results. You can't go out and solicit more votes to try and change the results of the election. Next question. If there's no new board candidates, can existing board members stay on the board for another year without a formal board election? So I'm a little unclear on the facts, because if you actually had an annual meeting with a quorum, then there would be no reason not to just have the election and allow the candidates to be elected again by the membership. If you didn't have a quorum, the board members would continue anyway, because they would not have been replaced by a new election. So the I guess the short answer is sure, board members can stay on for another year, whether they are elected because there are no other candidates, or whether they are elected by, or basically continue by default, because you don't get to have a new election. And if you have vacancies, the board is allowed to fill the vacancies. That's provided for in all of the statutes. And so I guess if there's something you want to add, Lisa, go ahead.
I guess I would just add that if a board that's a holdover board makes a decision, it's unlikely that a court would find that it wasn't done properly. So I think if there's a concern that you don't have a valid board, I think that's not a concern you need to hold if the board is holding over because of an inability to hold an election in that next year. And
Yes,
there's
and
case
you
law to
actually
support
had put
that.
in our notes here a
Yeah.
case where the
Yeah.
appellate courts have held that even where you have an association which year after year is unable to reach a quorum, that the board members who have been appointed by previously appointed board members still constitute a legal board, and that board has all the authority of the association.
That's right.
And that's in part because the fix is not to challenge that these board members are valid. The fix is for the owners to show up for an annual meeting and elect a new board properly.
Okay.
Yeah,
Should I go to the next one?
yes.
I'm going to try to summarize this one a little bit different than the question, or to summarize the question down. Essentially, this association has an owner that keeps becoming delinquent, pays some, falls behind again, keeps paying up and down, has reached out to the board, and has made some payments, but again, it's sort of an up and down situation. So the board is asking, what is the best approach to deal with this owner? They didn't want to put a lien right away, but it's becoming a burden on the community income. And they've been sending notices and want to know if they have to start resending notices all over again if the owner kind of keeps paying some off and coming back in. And I think my first answer to this is talk to your legal counsel for sure when you're having delinquency such as this, because there may be things you need to. We've talked before about the new statutes that require statutory notices of delinquency, regular notices of delinquency, limits on your ability to collect late charges and other administrative fees. So for sure, talk to your legal counsel when you are in this situation. We've also cautioned people to talk to their legal counsel in this kind of a situation because of statutes of limitations. It's likely unlikely in a situation where someone keeps paying for a variety of reasons, but you want to make sure that you're not waiting forever to collect against an owner when it is impacting the ability of the association to work. There is no best advice or best situation or best practice necessarily for an association in this kind of situation. You need to look at how this is affecting your community. The question said that it had become a burden on the HOA monthly income. If that's true and your association is having issues meeting its monthly obligations, um, you need to really consult with someone about ways to aggressively pursue collections of this or any other owner. Um, Make sure you're following your collection policy. If you have one of your rules that hold a collection policy, that will talk about when you send things, how you send things, what the late charges are. If you're able to collect interest, that should be in your declaration. Um, and again, keep an eye on the current statutes. Ken alluded before to we had a question about payment plans. Whether a payment plan is reasonable for your community has nothing to do with another community. So you have to look at what your community needs as a whole, what the owner is able to pay, and whether this is a repeat situation for that owner might be an issue, and how many other owners you have that are in a delinquent status with your association. I typically, when I talk to my clients, remind them that or talk about a payment plan that's longer than a year or that doesn't pay at a minimum the ongoing legal assessment or monthly assessments is probably not tenable for an association unless you have a really specific um, need to allow someone some grace in payments for a period of time. And I think you also need to look at what the board's role in this is. We talked before in our pre-meeting about Wakaiowa. So if you look at 6490-405, section 7, 8, and 9, they give the board discretion in their enforcement. And the board, it's 7 says the board may determine whether to take enforcement action by exercising the association's powers to impose sanctions or commencing an action for a violation of the governing documents which failure to pay is, including whether to compromise any claim for unpaid assessment or other claim made by or against it. So that means that the board could decide to waive the collection of assessments in any situation if they determined that was an appropriate action or result for that particular owner and the association at that time. The board also doesn't have to take enforcement action if they determine under the facts and circumstances presented that it's not necessary or not the right thing to do at that time. Subsection 9 does say that the board's decision under subsection 7 and 8 of this section, which we were just talking about, to not pursue enforcement under one set of circumstances does not prevent the board from taking enforcement action against another set of circumstances. But the board may not be arbitrary or capricious in taking enforcement action. And what that means is if you have one owner who's unable to pay for a variety of reasons, and the board elects not to pursue that owner or elects to write off some of the amounts due for that owner, it doesn't mean that they have to do it for the next owner that comes along. But they can't make sort of arbitrary decisions. They have to base their decisions on the facts in front of them and the situation that is presented to them, not because they don't like unit owner A, but that her situation is requiring assistance from the board or a payment plan or whatever the situation may be. I think I covered all that. Ken, anything I missed or you want to raise
Well, I think that part
specifically?
of the question was, do they have to start from the beginning
Oh,
if someone had made some payments? And I think that Lisa and I didn't talk about this one, but I think if an owner actually became current, meaning they paid off and got to current, even if the next month they then were, missed a payment, you would have to start over again.
I would agree.
But I also think that if they never became current, they're just making partial payments that, you get to go back to the process that started from its beginning point. So, I would say the really savvy person is going to pay off in full or get an agreement from you that you will accept whatever they pay as payment in full because they're trying to start a brand new process over again. Now, that doesn't mean that you have to wait 3 months or 6 months to pursue collections again, but you would have to give the proper notices and pre-foreclosure notices and limit what your fines or your late fees and admin fees are to comply with the new statutes. So that becomes one of the other variables in this, which is why you should be talking to your collections attorney and make sure that what you're doing would comply with your documents and that an attorney would be able to enforce it for you. We do have a number of clients who will send us collections matters where under the federal laws, the Fair Debt Collection Practice Act, we cannot pursue collections the way that our clients want because we are bound by these federal laws. And it I'll say disappoints a lot of those clients because we'll tell them they need to essentially go back and start doing things that they believe they've already done or they think are unnecessary because the law requires that we do that in our role as a debt collector, because these dues qualify under the federal law as consumer debts. And so we have the greatest protection under the law is provided to the homeowners. And that's, it's just gotten more and more cumbersome for the debt collectors and homeowner associations to pursue these unpaid assessments. And I don't think the legislature really understands how much more money it's costing, not just the associations, but the homeowners that the money is being collected from, because the fees are still paid by the delinquent owners. And it's the same as when the legislature goes ahead and, puts an additional $100 on every recording fee with the counties. They're not thinking about how much that is hurting the homeowners who get liens placed on their homes, because every time that happens now, I think we're close to $800 in fees to record and then unrecord a lien. And the legislature thinks they're taxing rich property owners, and instead they're taxing, a lot of modest income homeowners who are challenged in paying their dues. Anything else you want to add?
Nope.
All right. So next question. When and how do non-owners have access to an owner's account? So we weren't sure whether this question was about whether or not a representative of the owner was allowed to look at the accounts, like their brother, sister, mother, or whether it was a question about what an owner was allowed to see regarding their neighbor's accounts. And so the short answer for the first one is that, if an owner gives permission to their, representative to see their accounts, then they can see the accounts. Even in the collections process, if an owner gives written authorization to somebody else to discuss that collections matter with our law firm, then we can do that. We can't talk to them or give them any information if the owner has not given explicit permission for us to do that. Under the record statutes, which under Ukiah was 6490, 495, the association is required to redact information about some specific owner's accounts when a different owner has made a request. So the statute's got a laundry list of records which the information about individual owners has to be redacted. That laundry list is almost the same for each of the 4 statutes that apply right now. And so if you're talking about access to an owner's account, if you mean, the fine notices that have been sent to a neighbor, then that has to be redacted. If you mean the delinquencies, it's unclear because a lot of financial reports for the association, which the board reviews, are going to have the records related to delinquencies. And some of that, at a minimum, is going to be available to all owners. And it's not clear whether the names of delinquent owners is or is not a protected record. So if you're trying to get assistance for an owner, then they can give permission to somebody to help them understand their records. If an owner is just trying to dig up dirt on their neighbors, then I think the legislature intended that that would not be available records. But we don't have any case law yet which is examining what the legislative intent was or how delinquencies should be handled. We don't know that there's any law that prohibits an association from releasing information about delinquent accounts, even though we know the custom among most of our clients is not to release it out of respect for the privacy of the individuals. Anything you want to add on that, Lisa?
No, I think that covers it. The next question. Can 2 board members enter the condominium of a deceased owner to do a safety check, such as to turn down the heat or shut off the water? And I'm going to assume that this question has to do with a vacant unit. Because if it's occupied, I'm assuming that that's not that question is not relevant. I will say this is a pretty specific set of facts. And the reason for the entry and the timing of the entry are critical. So as we talked about, Ken and I talked about before, if this is the middle of the summer, it is probably not reasonable for the board to go into the unit and check and make sure that the heat is on or that the air conditioning is on or whatever, because there isn't really a risk of the pipes freezing, which is, I think, arguably what the question is about. Uh, you should certainly talk to your association counsel if you have questions about how to enter the unit, what kind of notices may be required, whether your governing documents allow for that. I'm assuming we're talking about a condominium, not single family homes, which would be a different answer. Um, Most condominium documents do grant an easement for access into the units for things like maintenance of the common elements. So there may be protection in your governing documents for that. Many of those documents also grant easements for access to inspect the unit for dangerous things or to check and see if the heat is operable. And so that might be very reasonable thing, or the water is off, that kind of thing. Again, it wouldn't be true if this is the summer we're talking about, but if we're talking about right now when it's fairly cold, that might be a reasonable reason to access a unit. I think unless there's an emergency, there's water coming out of the unit or something more urgent, you probably want to follow the procedures that are set out for mailing the notice, posting the notice on the door of the unit, giving, we will be entering the unit in X days at X time. If there aren't procedures set out in your documents, you probably want to look at something like the Landlord Tenant Act to see how what the requirements for notice are, because that's probably reasonable. A landlord may post notice, I need to repair somebody's sink, so they post a notice 48 hours or whatever the required statutory notice is to enter the unit. So if your governing documents are silent on access by board members or their representatives, the management company, then you may look to other statutes to see what a reasonable time frame might be. But all that is to say, if you're concerned about the situation in your condominium and you're not able to figure out from your governing documents what the correct notice or whether you have the right to access, I would certainly encourage you to talk to your association's attorney and make sure that you are drafting the right notices and publishing the right or posting the right notices before you enter. Again, if it's an emergency, that may be a different situation and you may have the right to do that without the requisite notice. But I think this sounds like you're kind of looking down the road and wondering if you have the right to do that. So I think check with your counsel if you have specific questions about that. Anything you want to add, Ken?
No, I think you covered it all.
Okay.
So I think this is the last question we had pre-submitted. If we restate our governing documents to comply with Ukiah, must the owners vote on each amendment or can they accept the document as a whole? So the general answer is that typically you would accept the document as a whole or reject the document as a whole. There's usually two documents, a set of bylaws which do not get recorded, and then a set of CC&Rs or a condominium declaration, which does need to be recorded. I would say that most of our clients do a simple yes, no on each of the two documents. It is possible to have multiple votes on different sections, especially if you are changing something within the document. So if you are changing maintenance responsibilities, or you're changing how the insurance deductible is to be handled, or you are changing something like whether you're allowed to have pets or allowed to smoke in the building, those are things which we might see pulled out as a separate vote for the membership. But typically it's here's a new 30 or 50 page long document to replace your existing 30 or 50 page long document. And most of the revisions are to comply with the new statutes. And the membership is, apathetic and doesn't want to vote. So you're out trying to get more votes. The more items you put on the ballot, the less likely people are to consider it, probably. So we usually do a fairly straightforward ballot with just the two yes, no votes. And if you've got something unusual or distinctive about how you're dealing with it, then you can make that a separate vote. And if you're working with our office, we can certainly help you figure out which ones you want to do with that. The challenge is usually trying to get people to understand why it's reasonable to change this. And we have some clients who just want to change it to adopt the mandatory provisions of Ukiah, and we can certainly do that. Most of our clients are adopting what you might think of as best industry practice. And some of those are governance issues, like we recommend you have a code of conduct for your board members, even though there's no statutory requirement for it. Some of that is related to clarifying ambiguity in your existing documents, which for a lot of condos and townhome communities means much more explicitly defining the maintenance obligations for the exterior of the building. So, yeah, I guess that's all I've got. If you have anything else, Lisa?
Not on that. It looks like we do have a number of questions in the chat. Do we want to go for those first?
Yeah.
Okay. Chelsea, did you want to read those or? Oh, you're muted.
All right, first question. After a lawsuit is settled, is the condominium association required to retain any of the documents, including the court documents?
I think that under the statute should be required to retain them all for 7 years. I think that's one of the specific records which the statute requires that you keep.
And I would add that the court pleadings documents are kept typically by the court as well. So after that 7 years, if you there's no reason to keep them, they're a record of their public record of the court, and your counsel may also have records retention stuff for that for the litigation file as well.
All right. What are the rules in regards to providing the financials to the owners before the board meeting? We have not received any since September, and we had a board meeting in December. We are meeting again tomorrow.
So I think that the statute requires that any documents that are provided to the board for a board meeting have to be available on request to all the other owners. So if a financial packet is being provided to the board for review at the board meeting, and an owner says, I'd like to see it, I think the owner is entitled to it. From a practical standpoint, I think that the owners should be given that document in advance of the meeting so that if they have a comment they want to make, they can do so during the comment period of the board meeting at the beginning of the board meeting. I think it would be against the legislative intent to refuse to provide any part of the board packet to an owner until after the board has had its discussion and voted at the board meeting. I think that is defeating the purpose of what the legislature is trying to do.
There may be some exceptions, Ken, if there's something that's going to be discussed in executive session, like litigation updates.
Yes, and that is an exception in the statute. Anything that can be done in executive session does not have to get provided to the owners either before or after the meeting. And so if you have a policy where specific delinquencies are discussed only in executive session, I think that that is something that can be withheld, but the entire financial report that might show the total delinquent amount could not be withheld. And, you know, I don't know why a particular board or management company would not be preparing financials and make them available. I would say most of the clients that I'm aware of are making the financials available on the web portals where web portals are used. And I think that web portals are actually a good idea for communities as the record retention process. If you can set up a website to store these documents, then the obligation of the association to store them for 7 years can be more easily met without the risk that those will be lost with a change in the board secretary or a change in the management company for the association.
It looked like there was a similar question, but the follow-up was what options are available for owners to get that financial information if it's not provided?
Well, I think that the information is only available if the board secretary or the management company is going to make it available. If they're not making it available, I suppose an owner can go to court to get a court order to force the compliance with the statute.
Another one,
Anything
Chelsea.
else, Chelsea?
Yeah. For filling vacancies, can directors be appointed when positions expired and the board prevent owners from voting for directors when there is quorum?
So this question will depend a lot on your individual association documents. I believe under the statute, the authority of the board to appoint to fill a vacancy is usually to fill the unexpired term. So if it was a 3-year term and the board filled the position and it's not due to expire for 2 years, then there would not be an election during those 2 years for that position. But a lot of governing documents will explicitly state that an appointment by the board is only until the next election, which would mean that as soon as the annual meeting occurs and you have a quorum, that position is open for an election again. So I've seen a couple boards try and manipulate appointing people into unexpired terms to try and avoid an election on them. I've seen it backfire spectacularly because that kind of manipulation to try and cheat the system so offended the membership that they got rid of all of the existing board members. So I don't know, exactly what the circumstances are and what either the person asking the question thinks is happening or wants to have happen. We are always in favor of allowing the membership to vote to fill board seats. And, if you feel like someone has been appointed and the statute and the governing documents allow for that person not to have to stand for election, the association still has the authority to call a special meeting and vote to remove those members from the board and then elect new members. So, the boards have positions which are subject to removal in a way that government elected officials don't have. So a city or county can't decide to just call a special election and remove someone that they put into office. That's almost impossible. But almost every community association has the authority with, I think, as little as 20% of the membership to call a special meeting and then go in accordance with either their documents or the statute to remove a board member that they feel is not properly there. Anything you want to add, Lisa?
Nope. Any other questions, Chelsea?
I was the treasurer for our board since December 2024, 20 years. In 2025, I found many errors in the financials, and the board is not providing my requests to see the actual invoices that they are paying. What are my rights as an owner to get my requests?
Well, I think invoices are financial records of the association, which every owner is entitled to see under the statutes. And this is sort of the question we had before. If an owner is not being given the records, then they can sue the association in order to obtain the records. I'm not sure that, I guess some associations have dispute resolution provisions that might require that you mediate or arbitrate. But I'd say for the most part, what you're describing is a set of circumstances I don't understand, because I don't know why an association would decline to provide the invoices which they have in their records. Those are also documents that should have been going to the audit or the CPA for an audit. And if an association didn't waive their audit requirements, then it should be something that gets taken care of.
I think that person had a follow-up on what statute should they look to get the financials. And I always just tell people to Google the word records and the statute they're organized under, and they should be able to find the correct one that applies to
Yeah,
them.
so for a condo, it's 6434,372. I think for a Ukiah community, it's 6490,495. Every statute has virtually identical language listing what records the association is required to keep. And invoices are one of the records that have to be kept for 7 years. And it says, that the association has to provide them within a reasonable period of time, and it states how they can be provided. Under Ukiah, the statute says that the records are supposed to be provided within 10 days unless it requires substantial redaction of information, in which case they're allowed 21 days. And the Ukiah actually says if you need more than 21 days, you have to get a court order to extend the time beyond that.
Ready for the next one?
Sure.
In general, if an HOA arranges a bank loan for owners to pay a special assessment over a long period and allows early payoff for those who wish at any time, is there any obligation for owners to pay the bank's interest beyond the payoff if there is no obligation or cost to the HOA?
Well, I would say no. If you pay off your full balance, you would not pay any more interest, just as the people who pay in full at the beginning don't pay any interest on the loan.
And I would just say that this is a bid for clear special assessment budget documents that explain how to pay, when to pay, and what the additional charges may be for an owner who elects to pay on a payment plan, et cetera.
But it's also a question that confuses me, and I'd want to actually see the documents
Right,
before I could give any kind of legal opinion.
right.
All right. The next one is the HOA monthly payments are now increasing to the point they are higher than the mortgage payment. This is creating a hardship on our seniors and fixed income owners. The reason is not because of lack of funds or reserves, it's because our property manager said the reserve study recommends 60 to 100% funding. What is the correct way to decipher reasonable percentages?
Well, I'm going to offer there's no correct way. I don't want to second guess the reserve study professionals' recommendation on how much money they believe should be collected in reserve contributions. But the board does not have to follow the recommendation from the reserve study professional. In the budget process, they are required to tell all the owners what the reserve study professional is recommending as a reserve contribution, and they're required to tell the owners whether they are meeting that or not. And, there's always the problem of balancing today's costs versus future costs. If you relieve the owner's burden financially by having lower dues and not funding reserves, you increase the risk that they will have a even more significant burden because of a special assessment to make major repairs. This is one of the challenges that boards face, is trying to balance today's needs versus funding future needs. There are a lot of different opinions about how funded an association should be. We've got, most of the reserve study professionals are pushing for a whole lot of money in the bank. So anytime something comes up There's enough to pay without a special assessment. Many of the reserve study professionals are pushing for 100% funded, which I personally think is excessive because the cash flow requirements will never require that funding. But, it is a challenge that the cost of homeownership and the cost of the expenses for a community have continued to rise, and people who are on fixed incomes are squeezed because they don't have income rising as fast. And the associations can't solve that problem. And I don't think the legislature can solve that problem either. A reverse mortgage might help some homeowners because it allows them to tap into the equity. Whether that's appropriate for individual communities or members of communities, it's just way too specific for us to know. Anything you want to add, Lisa?
Nope, not to that.
All right. Do we have to do an audit if revenue is under 50K? If the board did do an audit, do the owners have to vote to allow this?
So if you're under Ukiah and your budget is under $50,000, then you have to have an audit unless you get, I believe, a majority of all owners to vote and agree not to do an audit. So it's not that the board needs permission to do an audit, it's that the board needs permission from the members not to do an audit. And under Ukiah, there is no opt-out for a community that's got an annual budget in excess of $50,000. Anything you want to add, Lisa?
No, I just, if you're not a Wakaiowa community, you might have a different, for the new act, isn't it a number of units that determines whether you
Yeah,
can waive?
for both new and old acts, it is the number of units. But again, the audit is mandatory unless you get the required
owners.
vote from the membership. Under the HOA Act, again, the audit is mandatory unless you get the required percentage of votes at the meeting held, like at the annual meeting or a meeting held to reject the audit requirement. And I think under the HOA Act, it's 67% of the people in attendance. I think under the Condo Act, it's 50% of all owners. Essentially, the ability to get the membership to vote and avoid the audit is too great a burden if your community is large at all. If you're a 5-unit condo or an HOA with 10 homes, maybe you can reach those thresholds. But most of our clients and almost anybody that's got professional management can't meet the requirements to avoid the audit.
Any other questions, Chelsea, or are we done early?
That's it.
All right.
Okay. Thank you so much, everyone. We'll see you next week for another Q&A. Send your questions to info@condolaw.net if you have them for next week's session. Thank you.
Thank you.